Now, Public Protector Busisiwe Mkhwebane failed in her duty while investigating the Estina dairy farm scandal. The Gauteng High Court declared her report unconstitutional and set it aside. Around 200 million rand in public funds were siphoned off to a company linked to the Gupta family. ENCA reporters Aaron Bates and Michael Apple have been following the story for us. Of course, they join us now in studio. So, Aaron, first let's start with the judgment. Several errors of the law here.
Yes, and one example of that is where the Public Protector argued that she couldn't instruct the head of department, or the MEC of Agriculture rather, to investigate and interrogate the head of department because of laws around who is accountable to whom. And the judge in this matter said that was a profoundly incorrect interpretation of the law in terms of National Treasury precedents and also the Public Finance Management Act. And in fact that the MEC of Agriculture, there were several, but one of them was Mosebenzi Zwane, should have had the authority to call the HOD, in this case Peter Tabete, and interrogate him on his role in signing off this unlawful contract, the court has found, between a Gupta-linked company, namely Estina, and the Department of Agriculture in the Free State.
Yeah, now Mike, you've been following this story quite closely. You were at Estina, you basically lived there for a couple of weeks. I mean, when the Public Protector's report came out in this, many people were surprised.
Yeah. If we look at what the initial report said, and that's what I've got in front of me now. Of course, we've been overtaken by events, so what is said here now actually doesn't matter anymore. But this is what it initially said, and this is where the conflict comes in that was flagged by the court. If Ace Magashule, as the Premier of the Free State, is named as an implicated party by the complainants to the Public Protector, you can't have a paragraph saying the Premier of the Free State must initiate and institute disciplinary action against all implicated officials, because that would mean he needs to take action against himself. So it's conflicting. It places him in a conflicting position. Mosebenzi Zwane, who we know, and having been at a public hearing with the intended beneficiaries where the Public Protector went to Vrede, Mosebenzi Zwane, Ace Magashule, and another name kept cropping up, but Mosebenzi Zwane's name nowhere to be found in this report. Yeah. Very interesting.
So, talk about the unconstitutionality of this report, Aaron, because there are obviously gaps in it that a journalist can pick out quite easily. So it's surprising for many people to see that the Public Protector did not have all of the information needed in this report.
Although she had those three complaints, the original complainant was a gentleman from the DA in the legislature of the Free State, and he made three complaints between 2013 and 2016. The finding of the court is that the Public Protector simply ignored his last complaint, even though it was a few months before she finally finalized her report, which was tabled in February of 2018. The issue is that there are several stark differences between a provisional report, which was supplied to the current Public Protector by her predecessor, which set, for example, advice that there should be disciplinary action, named certain individuals. A lot of that information was essentially redacted and scraped out of the final report from the Public Protector. One of the findings of this judgment, which is really scathing, is that the Public Protector really didn't initiate and interrogate things as she is mandated to do in law, not only under Section 6 of the Public Protector Act, but also in terms of Section 182, I think it is, of the Constitution. And to touch on what Mike is saying there, one of the findings which I found pretty astounding in this judgment relates to the idea that Ace Magashule, then as Free State Premier, and Peter Tabete should be the people initiating a revamp of structures in provincial government to try and fix what seems to have gone wrong with the Estina Dairy Project. I mean, it simply doesn't make sense. You stand accused of doing something wrong, and yet you're the person who's told to mop it up. But you also haven't been found to be guilty. I mean, it's really astounding stuff. And this is what the judgment says. It says, to put people who are implicated in wrongdoing in a position to investigate that very same wrongdoing is absurd and goes against every known principle of law and logic. I mean, it's common sense.
Yeah, it is common sense. So what is the Public Protector saying about this common sense we're talking about, which the court has found?
Well, I did approach her spokesperson to see if we could get some response because, of course, the Public Protector does have avenues through the courts to challenge this decision. It's only at a High Court level as yet, and we know that in a similar decision in the High Court relating to her Reserve Bank judgment, that was challenged. She challenged the judgment against her, which included a punitive costs order against her personally for 900,000 rand. That is pending in the Constitutional Court, which, Shahan, is one of the reasons why this judgment excludes a decision on costs. That judgment in the the Con Court, which was related to a separate matter over the Reserve Bank report that the Public Protector filed, which was found wanting again by the High Court. So this is a second blow for her. That's pending. It's been 6 months. But in this matter, we haven't heard anything as yet. We know the Public Protector and her team are reviewing the judgment, and we hope that they will get in touch when they're ready.
Yeah, Michael, very quickly, because I've run out of time. I mean, given everything you've heard come out of the court today and you working this story, what happens now? Because money was siphoned off and nobody benefited, still to this day.
Well, somebody benefited.
Yeah.
Well, yeah, we know that a lot of money went overseas. It came back 30 million, I think, paid for the wedding. That was not flagged by KPMG. So somebody benefited in all of this. Look, where it goes from here, whether she reviews it or not, we're not sure of. But what has happened is that she has instituted another report by meeting with the intended beneficiaries. There, politicians are very clearly named. Just very quickly, the reason she gives for not going into as much detail and perhaps reducing the scope of that investigation was due to capacity and financial constraints. And she says she was simply not able to deal with the intended beneficiaries due to a lack of information. And she also mentions that she noted the Gupta leaks, but it did not form part of the scope of this investigation as well. So I think that report on what the intended beneficiaries have said, we'll have to wait for that.
Yeah.
Shahan, just to add to that quickly, from the judgment today, we know that in law there is a precedent for her to go back and fix what's wrong with the report Michael's looked at. So that's certainly something that could be done, and then there is the possibility of a legal challenge.
All right, thank you so much for unpacking that. Appreciate it. Both of them highlighted their reports. I'm very impressed. Thanks, guys. Michael Apple and Erin Bates.